Okay, good afternoon. This is Raymond De Leon with SmoothOperationofLaw, and today we're going to talk about trust protectors. What is a trust protector, and do I need one? This is for trusts. The trust protectors. What is a trust protector, and should you name one in your trust? Who pays trust protector fees? Learn the trust protector definition and who controls a trust, as well as why. Trusts go out of date and need to be changed, even irrevocable trusts. Trust protectors can do that without resorting to probate court, making them potential estate superheroes. For many trusts, we highly recommend putting the trust protector language key, protectors, trusts. Now, obviously, this comes from online. This is cunninghamlegal.com. All right, so I'm going to summarize as well as read. So I'm going to be reading, but then I'm going to summarize and also fast forward for time purposes. No one can see into the future, but with a trust protector, you can at least make sure your living trust can adapt to it. Now, it says living trust. Does that mean that you can't put it into an irrevocable trust? The answer is no. Of course you can put it into an irrevocable trust. As a matter of fact, trust protectors are a lot better for irrevocable trusts, as you will see shortly. Imagine this. A widow has her estate planning attorney draft a revocable living trust with the provision to divide a large sum equally among her 4 grandchildren, who are specifically named in the trust. A few years later, she passes away. As happens with all revocable living trusts, upon the grantor's death, the trust becomes irrevocable, meaning it cannot be changed or modified without the trustee getting into major legal trouble. The problem between the time the original trust was drafted and the time she died, one of the widow's children had twins. Although the trustee who controls the trust feels sure that the woman would have wanted to make provisions for those 2 grandchildren, the trustee is legally bound by the exact terms of the trust and therefore can only distribute money to the 4 grandchildren named in the trust. The solution? A trust protector. A trust protector is a third party, usually an attorney, not always, but usually an attorney, given the power within the trust and by law to allow the trustee the power to do the right thing and modify the terms of the irrevocable trust to comply with the grantor's intent. In this case, that would mean assuming the woman would have wanted to include the 2 new grandchildren in the living trust. So the trust, let's stop right there. The trust is irrevocable at this time. If you, in your indenture or your declaration of trust, that is, draft in the legal terminology and appointment and the discretion and direction and purposes and powers of a trust protector, then the trust protector acts almost like a non-accounting party, usually like a non-accounting party. But what they do is they look at what the trustees are trying to do and they can give the go-ahead. It's almost like a separation of powers so that the trustee isn't making any unilateral changes to the trust in order to try to now blur the grantor's true intention. So it's a separation of power. Their whole job is to protect the interests of the beneficiaries by preserving the intention of the grantor that's written on the declaration. But in certain circumstances, the trust protector, by knowing the intent and the love and the type of person that the grantor was, they can make a call to allow the trustees to then modify the trust indenture so that they can further complete the ultimate goal. The trust protector has the power to green light discretion. They also have the power to freaking kick out trustees who aren't doing their job. They almost act like an adjudicating party without having to bring in the courts. All right, let's get back to this. Now, if the widow's estate planning attorney had the foresight to appoint a trust protector within her trust, the trustee could now legally distribute the money between all 6 grandchildren. Without a trust protector, the whole family may well end up in probate court, possibly for years, as money flies out the window. And that's not even touching upon the hostilities a contentious legal process would create between family members. For any long-term trust, a trust protector can potentially solve a multitude of similar problems after you're gone, saving your family time, money, and a lot of strife. Now, it says, should I worry about the power giving for a trust protector? Trust protectors have become a common feature of many trusts created by up-to-date attorneys. Even the clients do sometimes express concern about giving power over a trust to a third party, even a reputable attorney. Clients ask, how can I give that kind of leverage to an attorney? What if they decide to do something really crazy? Okay, guys, let's stop right there. First fucking off, I said that it doesn't always have to be an attorney. Not always. Doesn't have to be. This little freaking article is solely talking about an attorney, but it said usually it's an attorney, which would indicate that it's not always an attorney. None of my trust protectors are attorneys. None of them. Why the fuck would I want an attorney in my shit? Okay, so let me assure you, okay, let's get back to reading. Let me assure you that in my 26 years of practicing law, in my affiliations with numerous legal groups, and in my discussion with innumerable estate attorneys, I have never found a single case of a trust protector going rogue. Okay, let's stop right there. Hey, sometimes there's unjust enrichment, or they try to influence trustees to collaborate with them. Yeah, you could get them disbarred by filing a freaking complaint with the ABA for unjust enrichment, and they'll be disbarred and have to pay. And the ABA has a legal judgment fund where, if proven, they're gonna fucking pay you. And they usually do that through arbitration. But now let's move on, because I want to go down to how do we say? Something a little more important. How about that? Okay, here we go. The protector definition. Before we go on, let's back up and clearly define our terms. What is a trust protector exactly? Officially, a trust protector is a disinterested person. Almost always, not always, almost always, an attorney named within the trust who has the power over the terms of the trust, but who is not the trustee. The trustees themselves are fiduciaries, meaning they have the legal and ethical responsibility to take care of the money and assets of others. In this case, the beneficiaries of the trust. As fiduciaries, trustees are strictly that is, like slavery, strictly bound by the terms of the trust, and have the responsibility to do so. A trustee must carry out the terms of the trust exactly as written. The trust protector cannot, for example, make a payout from a trust. Only the trustee can do that. But the trust protector can modify specific provisions to conform with the grantor's intent or when circumstances change. They can correct errors or omissions in the trust, but they do not replace the trustees. Crucially, the trust protector can give new instructions to the trustees. This helps ensure that the trustee is lawfully permitted or in other circumstances required to do the right thing. Indeed, in order to make sure the trust conforms to the grantor's intent or to ensure the trust remains fair and equitable, the trust protector has specific authority to change parts of an irrevocable trust. Authority to change parts of an irrevocable trust. Such changes would normally be possible only through the courts. So in essence, a trust protector is, in part, substitute for a judge and a court. So now you don't got to waste legal fees. See that? Vital trust maneuverability. Now, how trust protectors came to have their powers. At this point, you may well be asking how it became possible for an irrevocable trust to include something like a trust protector clause at all. After all, when you set up a trust and you name the trustee, you say, in essence, the trustee is going to do these things in this manner, in this order. So how is it even possible that could change? That could be changed by a third party. To understand correct law, it's worth looking into the back history. Okay. I am not going into the fucking full-blown history. No, but Raymond, come on. I am not going into the full-blown history. But what I am going to do is I am going to summarize what the history is. Look, guys, laws change. Situations change. You might have not been able to carry out a certain function lawfully, permissible. So what happens is that your trust might be operating in illegal type of behaviors by the state. But here's the thing. A lot of the trust business should not even be public. So why the fuck the state would even know what the hell you're doing in certain instances is beyond me. Keep your fucking mouth shut. Trustees, keep your fucking mouth shut. Okay? And here's the other thing, which is not mentioned in this document. For beneficiaries who think that they could bring their trustees to court with wasteful litigation, you bitches, hear this. If the grantor is smart, he will put in what's called a no contest clause. A no contest clause in his indenture, the same way you would place in a trust protector clause, will allow for the grantor to scribe into that law of that trust, while as he writes his indenture or his declaration, to say, hey, if a beneficiary brings a suit and challenges the trust, after I've done put in this trust protector and these trustees who are going to administer both the indenture, carry out the duties, and handle the accounting for the beneficiary's interest. If that fucking beneficiary is such a bitch that he induces legal proceedings, he forfeits all of his beneficial interest of this trust. And therefore, because he is no longer a beneficiary, upon his action to bring legal interest into this trust, losing that particular position of beneficial interest no longer allows him to have the standing in a courtroom by default. And therefore, you know what the probate judge or the chancery judge or the court judge is going to do at that moment? When you present that no contest clause, he's going to say, oh, good initiative, bad judgment there, beneficiary. And he's going to say, you don't have standing to bring this in because according to the grantor's intent, you have X'd yourself out, you simple bitch. And then poverty. Fucking poverty. So now, let's keep on going. I'm going to now show you guys something cool, okay? This is a Microsoft Word document junkyard of mine that allows me to siphon in specifically already pre-drafted trust protector language depending on how much authority and power I want to give the trust protector. So I do copy-paste, copy-paste right into the trust protector's provisions on the trust. Okay, so number one, trust protector. The trust protector is to assist, if needed, in protecting the interests of the beneficiaries so as to achieve the objectives of the settlors. You could change it to grantors, doesn't fucking matter. Of the trust. Each power and authority granted to the trust protector in this instrument, which would be the declaration of trust, that is, unless the capacity is otherwise specifically stated, is conferred in a non-fiduciary capacity. Now, my trust protectors are goddamn fiduciaries. You hear me? You hear me? Goddamn fucking fiduciaries. The reason why is because I need those motherfuckers to not ignore any strife of my beneficiaries because I place in a no contest clause. So they are the only remedy. And whoever those trust protectors are, those motherfuckers better be wizards in trust. They better understand how best to carry out a grantor's intent and to look at injustices. So if you have a piece of shit trust protector who isn't protecting shit, then you as a grantor are an idiot because you are not protecting the trust after you pass on to the next living standard and phase out into the black. You have done your beneficiaries a disservice and to yourself. So you better fucking know how to carry out your intent and make sure that the guy who you put in place of the courts understands your intent well and understands trust law well to make sure that in the future, if something needs to be modified, because they're supposed to survive you, if something needs to be modified, that they're the go-to guy to understand your personality and your personified interest in that trust. And then I'm just going to keep going down. See, powers granted to the trust protectors. This is an example. You can change. You can change the languages here. All right, so now, be advised. I'm not going to scroll anymore. I'm going to stop at power to amend trust agreement. The trust protector may add or modify the terms of the trust to protect the purpose of this trust. 2, alter the administrative and investment powers of the trustee to comply with any changes in the law. 3, add or modify terms of the trust to reflect tax or other legal changes that affect trust administration in. Wait, did I say 4? Okay, that was 3. 4, clarify or correct ambiguities, including scrivener errors that might otherwise require court construction or reformation. Now, guys, notwithstanding the foregoing, the trust protector shall not amend this agreement to limit or alter the beneficiary's right to trust assets. That means the trust protector is not going to add in a no contest clause. Grantors, get your fucking goddamn ink sticks in your brain. You better put that shit in there. An amendment to this trust shall be made in a written instrument signed by the trust protector. The trust protector shall mail by first-class mail a copy of the amendment to the beneficiary and the beneficiary's legal representative. The members of the trust advisory committee, if serving, and the currently serving trustee. You better give notice. Now, let me be the one to tell you. If you are drafting an irrevocable trust and your shit does not have specified trust protector provisions, you're an idiot. Idiot. But Raymond, stop making ad hominem personal attacks on us. We didn't know. Good. Now you know. Okay? You don't want your shit in court, right? Because then it becomes bullshit. So make sure as a grantor, when you grant this, you're smart enough to be granting a trust. I'm going to say this again. How many videos do we see where people actually talk about the trust protector? They don't. They're always talking about trustees and we're going to make an organization and we're going to try to do business or put trusts or land patents and all this stuff in the trust. They don't know how to run a fucking trust. They don't. So, I'm here at Smooth Operation of Law giving you some insight. I'm not going to go any further because I don't want to beat a dead horse and going through all of these type of provisions. But I've given you guys pretty much the idea with a legal public website on the definition of a trust protector. And then I opened up my own personal paperwork. Showed you what kind of shit you could have. Language. Okay? Language that you can have inside of your freaking trust. These are things to think about. Any questions? Go ahead and hit me up. Okay? Link is in the description. Okay? Link is in the description. How to contact me. Do not contact me. Do not contact me. This is the only time I'm going to say do not contact me. Do not contact me if you're just like, you don't really know, how do I say this? Let me put this. Hey, contact me if you're serious. That's all I'm going to say. Contact me if you are serious about establishing, this type of knowledge within your trust. That's all I'm going to say. All right. That concludes my class, meaning my video or it's not even a class. It's me reporting what exists. There's no attorney-client relationship. You go get a goddamn attorney for that. Hey, as a matter of fact, at the top of this page, legal advice should be sought before any language is inserted into a trust. Go do that. But I'm glad you guys listened to my video. And as usual, I'm going to give you top-notch energy. And I appreciate it. All right, that's it.